What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm Rich.
What's going on? This is Colin. How's everybody doing? Hopefully you're having a great day so far. Happy Friday. Happy Friday. Yay. It's Friday. Yay. Yay. It's Friday. Anyways, you guys want to watch some court? I want to watch some court. Let's watch some court. I've got some good ones tonight. I've got a new court that I haven't covered yet. There's yeah, it's a Michigan court. I can't remember the judge's name off the top of my head, but we have an AI fail. It's a little bit of a longer case. It's going to take about half of it, like 25 minutes. But yeah, we have an older attorney who's, you know what? We'll just watch it here in a minute. Then we've got a couple of small ones. We got a Judge Simmons clip. Got another short one. I can't remember the judge's name. Yeah, so we're just gonna have a fun. And then we're gonna end it with Judge Simpson. He had an interesting case today. Someone who made threats against a elementary school. Yeah, an emergency bond hearing. I guess that's what you can call it. I don't know, but the whole thing just it's interesting. We'll watch it. That's at the end. So yeah, we're gonna do it. And real quick, Muse is here. What's up, buddy? What's up? I've got an important thing to say, but you know what? I'm gonna wait till after the first clip to say it because I don't want to say it over and over again. But we are gonna be helping Muse with a GoFundMe this evening. Well, over the next couple streams, we're gonna be helping Muse. But I don't want to. Yeah, I don't want to. I don't want to say, hey, I don't want to give the whole spiel and then have to say it multiple times. So it's an important thing, and it's for Muse. He's a mod here, and we take care of our own, right? We take care of our own. So I'm gonna post the GoFundMe link, and after the first case, I will share the story with you guys, and yeah. But it is legit. Like I said, we take care of our own. So we're gonna do that. But I'm just gonna post it for now, and I'll tell the story after the first case. But first one, AI fail. AI fail. I feel like someone just rated. Did someone just rate? Because I just went from 30 viewers to 150 in a second. Did we just get a big in raid? I'm waiting. I'm waiting to see it in the chat. My chat's a little delayed, so I'm just waiting, real quick. No one's saying anything. Maybe just a lot of people joined at the same time. I don't know. All right. Well, you know what? Let's get back. All right, coming over for Biggin. There we go. There we go. Biggin. I had a feeling. It's like, yeah, the numbers don't jump up that dramatically, that quickly when there's not a raid. Biggin, thank you so much for the raid, my friend. We are just getting started. So yeah, Biggin, you are awesome. Thank you. You haven't missed anything yet. The first case is a it's a weird one. There's a lot of law, let's just say that, but it's an AI fail. The defendant comes to court. Can you call it a defendant? It's not really. It's not illegal. It's not a criminal case. So I don't know if it's technically a defendant, but he's in court. He brings AI arguments, and he is so confident. So it's good. But gotta go through all the court stuff first. Big and you are awesome. Thank you so much for the raid. Again, I am dropping Muse's GoFundMe link. I'm gonna pin it. And yeah, after the first case, when a lot I mean now that we have 200 people here, I feel like I can just tell the story now. But I'm gonna wait to tell the story after the first clip. So anyone that's coming in late I don't have to retell the story. So but it is very important, and Muse is one of our own. We take care of our own, right? All right. Anyways, now we got some super chats. Bella, thank you so much for the super chat. No, you're awesome, Bella. You are awesome. Thank you for the super chat. I appreciate it. Sherzad, thank you for the 18 months, a year and a half. That is awesome. That is awesome. Thank you, Sherzad. You guys are awesome. All right. So let's get into it. Look for the GoFundMe. It'll be there. You can read the story, but I will summarize it after the first hearing. But like I said, it's for Muse, and we take care of our own. So let's go.
Meantime, let's move on to the next matter. I see Attorney Burlingame is here. Corona versus Corey Tala.
Oh my gosh, is this volume really low? I was having this problem with this court. I was having a big problem with this court trying to make videos on it. Sometimes it sounded fine in my editor, and sometimes it didn't. Yeah, it's really low. Man, this doesn't make sense. Why in my editor it sounds it sounds fine, but when I'm watching the court live, it's really low. But in my editor, it was fine. All right, I'm gonna play it for a minute. If it's too low, then we're not gonna play it. I'll just edit it and we'll fix it for tomorrow, or not tomorrow. Tomorrow's date night. I'll fix it for Sunday. But this is bad. I don't understand. I don't understand why my editor makes it sound so loud and then it's low.
Mantes. But
Yeah,
let's hear them.
this is unplayable. I'm sorry, guys. This is breaking my heart because this is a really good one. We got an epic AI fail. All right. Um. Yeah, if it's low for me, it's low for everybody else. We're just gonna skip this case, which sucks because that means tonight's live is gonna be short. This was kind of half the video, but it is what it is, right? Hold on. If I skip halfway through, we'll get better.
All I had to do is show
No,
70.
nope, still not better. All right. Well, that's a fail. Again, I don't know why my editor makes it sound so loud. I'm trying to find the. Hold on. I'm just trying to find the next
Shall
case.
file a bill of costs with the clerk's office. The clerk. The property you absolutely would not get fined for. Okay. Yes, absolutely.
All right. There's only about 10 seconds left from here on. While this is going, I'm gonna pin the link.
It's frustrating, and it's just too bad that it lined up the way it did. And I do wish you the best of luck, Mr. Schmidt. Thank you. Court's in recess.
Okay, Miss Clifton.
Oh, well, hey, there we go. All right. Sorry. This is turned into an epic disaster. I don't know if Muse wants me to share the GoFundMe link at this point. All right. GoFundMe for Muse. It's not working. I'm so good at this. I am so good. All right, I'm gonna pin it. All right, it's pinned. I'm still gonna wait a case, so we're gonna watch this short clip and then I'll tell the story. All right, you guys are awesome. Sorry, I just cut the entire video in half, but yeah, if we can't hear it, we can't hear it. There's no reason to play it. I'll fix the volume for Sunday night. That's a good case. It's a fun listen, but yeah, we can't hear it, and I got to figure out why my editor is messing up. That's me, by the way. All right, MB, don't do that. It's not an awesome stream, but thank you. I do appreciate it, MB. You're awesome. Also, Susie for 3 months. Thank you so much, Susie. I do appreciate it. All right, let's get into. Hold on, I miss Shane. I miss Shane for 23 months. Shane, thank you. You're 23 months. You're almost at 2 years. That's awesome. Thank you. Okay, let's go. We're starting here now.
Wait, you got to unmute it, Miss Ferguson.
There we
you
go.
All right.
Sorry about that.
That's okay. This is case
Okay.
number 25014-121CH, Pamela Ferguson versus Gary Ferguson.
Correct.
State your name for the record, please.
Pamela Bergeson.
Okay, Ms. Bergson. So, tell me what happened. You have to give me a little bit of procedural background, not a lot, just an overview.
Okay. Okay, this is a foreclosure on my home at 40701. I'm sorry, 47635 Belmont Drive.
In
And
Van Buren Township.
Van Buren Township, Michigan, 48111.
Mhm.
And that occurred, the foreclosure was August 22nd of 2024.
Okay.
And I was evicted on June 18th of 2025.
Okay.
I am now currently renting a hotel room.
Okay. Now, what happened? It appears that the property was sold for what amount?
I believe it was, I don't have the actual foreclosure amount. I
But-
do have the paperwork here, though. I
But
can get it.
you
for
have
you.
it in your motion. You got your motion in front of you?
Yes, I do. I'm pulling it
Okay,
up
look-
right now.
Okay.
And I do have the motion in front of me, and $184,200,
Okay, and then that was in excess.
excess of 74,000.
Okay, and the balance after everything is satisfied is what? After all the debts, go ahead.
The excess of surplus funds was $74,000. I received half of that amount delivered to me via the Wayne County Sheriff Office on June 26th. $37,000 check was delivered to me.
Okay,
And I was, go ahead.
The reason I think what happened was that because you own the property jointly.
No,
with your
it's not
husband?
jointly owned. No.
It wasn't? Did you?
No.
You didn't attach that? I don't have that. You need to show me the deed where it was solely in your name. Do you have your deed?
I don't have the deed. They foreclosed on me.
No. Before, when you own the property, they had to be recorded when you
Right,
got the property. So
correct,
I need that to see that you're saying that the property
Okay.
was solely in your name, and I
Correct.
need to have verification. I can't. So what you need
That's
to
at the Wayne County Register of Deeds office. I was evicted. I now own nothing.
okay,
All
but
of my property was put into a dumpster, and I own nothing right now.
okay, but I need to have that information. I
For
need
the
to
Wayne
have that.
County.
No, ma'am. This is your motion. I need to have that information in front of me to prove that you were the sole owner of that property in order for me to release the additional funds. So I don't,
So I need to get a copy of the deed and get it to you and
yes.
get this rescheduled again.
No, we'll give you another date. We're gonna give you another date.
Oh my goodness.
Yeah, I can't do anything, ma'am. I need that. So do you want me to put this out? Let me see, today is the 30th. 1, 2, 3. We can put it out.
No.
No, I have
This
to put
needs
it.
to be as soon as possible because the issue has now become urgent.
Okay, but what I'm saying is I'm trying to give you time to get the documentation. I can
That
put it
can be
out.
requested online very quickly, ma'am. I
Okay,
can get
so I'll
that to
put
you
it
by
out.
tomorrow. Yeah, I
Are
can get
you
it by tomorrow.
sure? Because I'll put it out to the 6th then.
Yeah, I can get it.
Not tomorrow, Monday.
Yeah, I'm going to go on the Wayne County
Okay.
Register of Deeds website and request a copy of it.
Okay. And
I don't know what their protocol is as far as electronic delivery versus mailing. I don't know.
You're gonna do it electronically, right? So
I'm going to try to. Yes.
Okay.
Yes.
Well, I don't want you to have to come back and we don't have it. So that's why I'll put it out 2 weeks. I'll put it out a week, but if we don't have it, man, then we're gonna have to
I
come
should
back.
be able to get it. I should be able to get it within a week. If I cannot get it electronically within a week, I will drive there and get a copy. I know I can do that.
Okay, so we'll put it out to the 6th. We'll put this over to the 6th, okay, via Zoom.
Sure. That's fine.
Please make sure we get a copy and then we'll handle it then. Okay?
Okay, that sounds great.
Okay, thank you very much.
Thank you.
Okay, have a great weekend.
You too. Bye.
Bye-bye.
Yeah, that was supposed to be a quick palate cleanser after the AI complete meltdown of the first case. So yeah, it doesn't really make sense to start off the show that way, but yeah, she was fun, and I don't think she understands what's going on, but whatever. Anyways, I did promise you guys to tell you about Muse's situation. So I kind of took a stance a couple months ago to stop doing GoFundMe's because, just I was getting a lot of them, especially after the Haley matter. Like I was getting a lot of people asking for GoFundMe's, and I believe everyone that's asking me, but it's just I didn't want to turn into that channel where I was always asking. I didn't want to be a fundraising channel, but Muse is one of ours. Muse has been here for a long time, which is why Muse is a mod. So yeah, like I said in the intro, we take care of our own. Muse's ex-wife is going through a situation and needs help with some medical expenses. I don't want to say a ton on YouTube The GoFundMe link is there. You can click. They do a great job of breaking down the entire situation. But one of the reasons that I did, besides the fact that Muse is one of our own, is decide to push this is they've already raised half their goal, and like I feel kind of I feel better about GoFundmes when people do that. They don't just make one and then send it to me. So we got two things going for us. One, Muse is one of our own. Two, they're not just sending it to us to hopefully make a quick buck. So I appreciate that, Muse, and I appreciate Muse. So all the hard work he does every night on the channel as a mod, I have no problem pushing this. If you guys can donate anything, that would be awesome. I don't really, there's not really much more to say because I don't want to go into details about the story on YouTube. There, like I said, click on the link and you can read the entire thing. If you can donate $1, awesome. A couple dollars, even better. Like whatever, let's just take care of Muse. So Muse, I know you're here, and hopefully I did that justice. I'm not really good at the whole fundraising thing. I'm really not. But you know, if we can get it, closer to the goal, that'd be awesome. And I mean, yeah. So you guys are awesome. Thank you so much. And I saw Phil's name's already there. Phil's awesome. Phil Phil donated before I even saw the message. No, that's not true. But yeah, it doesn't matter. But Phil started off for representing the community, so thank you so much, Phil. I do appreciate that. I saw it. Anyways, we're gonna move on to the next case now. Muse, you are awesome. Hopefully this all gets figured out because that's terrifying. It really is.
2 months and 13 days and needs a new engine. This is ridiculous. Your Honor, I am young. I was trying to set myself up for success.
I'll agree to that tonight. So that's true for tonight. I love you, Bill.
I've gotten to the place where I am working and really want to be a responsible adult, but that can't happen when those who trust advantage people. Now I understand motor cars believe they were not properly served. I received an email response from this JSG process server during each attempt, including the day they were successful. I have those here for your review.
Okay. Thank you for sharing that. And you shared more than was required because this is just a motion to set aside a default judgment. So you really didn't have to rehash the case, but you did give overall spiel about how you position this case. I do have a question though. You said the car was towed as abandoned?
Yeah, and
how did they get the car?
It was probably in the, I'm not even, hold on. I don't know how they got the car. Unless it was already towed.
Wait, did you bring them the car, are you saying? And I'm confused. Where did they tow the car from?
Yeah, they had the car because the engine was down.
Oh, okay. And so they were in possession of the car, and then you said that the date that they were served,
They towed it.
they towed the car where?
To PJ's towing.
Oh, okay. Because they reported it abandoned. Got it. Okay. Again, Counsel Baldori, the court rule is the court rule. I don't know how old you are, ma'am. You do look rather young. Are you over 18?
Yeah, I am.
Okay. The court rule is the court rule. You gotta give me good cause in a meritorious defense. Your defense is that you would like to litigate the merits of the case, that the car was sold as is. That doesn't necessarily address whether or not there was some element of fraud or misrepresentation in the sale. And you've not provided, I don't think, sufficient details even to address that. But my bigger concern is the good cause. You got a young lady here who, she says she's over 18, but she doesn't look over 18. That bought or purchased a vehicle and had issues, said the car was in the possession of your client. They were served, we have a valid proof of service saying that they were served on October 14th at 11:55 in the morning. You have a licensed attorney at the time who has an appearance on the case, is required to file an answer. And we have no reasonable excuse as to why an answer was not filed. I recognize Mr. Mataloni later passed away in December, but he was not, there's no information the court has that he was hospitalized, that he was ill or unable to perform his duties on or about the time between October 14th and November 18th when a default was entered. And then we didn't even get a motion to set aside a default until over a month after that. So I don't believe that you have provided the court with good cause.
Can I address the court, please?
Can you not cause as to why there was a default in the first place? Now, did you have something you want to say?
I'm sorry for cutting you off, Your Honor. I apologize for that. I just think that my client might be able to address the court on this. He was involved in the matter prior to myself. He's told me that he was not served with the actual summons. I understand you're seeing that something was served in October. I'm not, I don't have that in front of me, but I hear what you're saying. And certainly my client was relying on his attorney at the time, and I can't speak to what was happening with Mr. Mataloni. I understand it was probably his responsibility, but my client's also saying that he was not served with the summons. He was served with the change of judge document. Now, I don't know because I wasn't there and I wasn't part of it at that time. So it's hard for me to speak directly to that, because I wasn't there. But my client was relying on Mr. Mataloni to make sure this was handled and got in. And I don't know if he was really served properly. I understand what the court is seeing in the Register of Actions and in front of the court.
I'm looking at, it's not the Register of Action. I am looking at the proof of service. It's a certificate of service that said that they personally served motor cars of Lansing, care of Gene Badawi, I believe, registered agent.
Right. Okay.
And there's a copy of the summons and the complaint attached.
Okay, and Mr. Badawi is on Zoom right now, and if he's got something to add, maybe that would be helpful for clarification. But I can just say that what Mr. Badawi has told me is that he gave the file to Mr. Mataloni.
I believe that.
Yeah,
I believe that he hired Mr. Mataloni. I believe that he gave the file to Mr. Mataloni, and I believe that Mr. Mataloni was supposed to file an answer and that he did not file an answer. And had this answer been due during the time in which Mr. Mataloni suddenly passed away, that would be a different argument. But that's not the case. The default was already entered, and Mr. Mataloni was still alive and appearing in court on other matters.
I understand, Your Honor. Well, I would like to at least.
So my judgment is that the motion to set aside defaults is denied. Any additional matters for the record?
I would maybe just like my client to be able to place, his side of it on the record, since he was the only one there on my side that was actually present, if the court will allow it.
It's quite atypical to have call your client after the court gives a ruling. It's not going to change my ruling. He can tell me that he hired an attorney. He can't tell me why the attorney failed to file an answer, which I have that he was served. So that there's nothing he can do to tell me why their answer was not filed.
I understand. I really just wanted to hear what he would say about the service document. And I understand the court's not going to change its ruling. I just wanted to hear what he would say and place it on the record.
Yeah, proof of service is an affidavit, which we know is a sworn statement. So there's nothing he can't tell me that he didn't receive it, because I have that he did, and the time that he did. And he was served by a agent to properly serve him. We don't just send anybody from the court to serve him. So for him the young lady didn't go serve him herself. There was someone who served him.
Well, okay. Yeah, all right.
Any additional matters for the record?
No.
Okay, you're all set. Thank you.
Judge Simmons. Judge Simmons is one of the few judges that I watch regularly that just doesn't put up with anything. When she makes her mind up, she's like, no, that's not happening. Like the video I did earlier where the guy was held in contempt. She warned him, if you keep talking, I'm going to hold you in contempt. He said one more thing, and she's like, okay, contempt, 93 days. Uh, it's refreshing to see judges like that at times. Was that warranted? Yeah, this one was. The contempt, yeah, maybe. Yeah, you can go watch my earlier video today to see that. But it was good. All right, let's go. I think we're actually moving to the Judge Simpson case. This is a serious one. This was supposed to end our evening. So like I said, we're gonna have a little bit shorter of a live stream since I had to cut out a 20-minute video because the volume was too low. But this is Judge Simpson. We have a defendant who made some threats against a school, and the attorneys filed an emergency bond motion. I don't know if it was the prosecutor or the defense that did this. So the bond was set at $250,000, and it was posted. And I feel like after it was posted, the prosecution may have tried to raise it to 2 million. Something weird happened. So I read an article. I can't remember who sent it to me. I'll go through the list. It was either Lucy, Twitchy, or MGT. One of those three sent me the article, and so I was actually able to read what happened during this case, and it's interesting. So this guy again made some threats against the school, and was set a bond at $250,000. Posted the bond, and now we're back in court. He posted it yesterday, I think, but 2 days ago, and he's still in jail because I don't know. We're gonna watch it together. Full disclosure, I've only seen 10 minutes of this 30-minute clip. Full disclosure, so I'm trying to break it down or try to summarize before we start, but it's good. Let's go. I mean, it's Judge Simpson. It's gonna be good, right?
Court does call the case of the people of the state of Michigan versus Jules. Is it Calhoun?
Ron Brown on behalf of Mr. Calhoun.
Andrew Childers appearing on behalf of PPR.
Your name, sir?
Jules Calhoun.
All right, thank you. All right, this is it's entitled People's Ex parte Motion for Modification with Bond Conditions. I don't know that it was as filed ex parte in any respect whatsoever, because I think it was communicated to all parties. That's the first problem. The other issue is that typically these motions are filed. Court's first determination is whether or not the necessity for the court's action constitutes an emergency. I'll be frank with you, I'm not convinced that it does constitute an emergency, but given everything, the court is choosing to hear the matter. I really don't deem it an emergency, so that you're clear on the court's perspective. All right, but is your motion? Go ahead.
All right, before I begin, and thank you for that, thank you for accommodating this motion. Because I'm a little unclear. Talked with Ms. Scott from the defender's office. My understanding is there was one order, and then and I think there was an error or an issue with what are specifically the defendants with respect to GPS tether and exclusion zones. What are those conditions if nothing changes with respect to the defendant's bond as we sit here today?
The original order that was entered by the magistrate on the 28th, and I'd have to go back and look at the hearing, but I don't know that there was necessarily an objection from the people, was for location tracking only on a GPS tether. That subsequently, and again, I'd have to go back and look at the hearing. I didn't have the time to review the video of the hearing. That has subsequently been changed to exclusion zone with location tracking only. So the change wasn't to, just added an exclusion zone. And the only area that was added, which again doesn't when I look at the requests, the written requests that were made by the people, doesn't make much sense to the court, given my knowledge of the area, is the address of Hazley Elementary School, Ann Arbor. That particular address is the hot zone.
It's Hazley Elementary School.
Is Hazley Elementary School.
And so that, as the order currently stands, if the defendant were to be released, there would be an exclusion zone of the elementary school on its GPS tether.
As I read this order, yes, but again, given my knowledge of the area, I have concerns about how this is written. Because, and I'll just lay it out to you. I mean, I'm one that is full disclosure.
Yeah, MGT. I'm not fully. I looked at the article. Was it you that sent it to me, MGT? Yeah. All I'm going to say is he made threats against an elementary school. I don't really want to say anything else. The article is more about if it was you that sent it to me, the article is more about the outrage that the people of the school got a 24-hour notice that he made bond and he was going to be released. So that was the outrage. That's why there's so many people in the courtroom. So there wasn't a ton of backstory in the article. Even the article said that the actual threats that were unclear at that point. So maybe I just didn't do enough research on it. I mean, I didn't. I read the article and that was it. So yeah, I don't know.
Hazley Elementary School is my elementary school. I know people didn't think it existed way back with the dinosaurs, but it did. There are 4 entrances to basically 4 access points to the Hazley School grounds that come off of different neighborhood streets into there. So listing just the address, I don't know, quite frankly, is specific enough to cover the area. I mean, for the most part, most of the people that, if they were walking there, would not enter necessarily off of Duncan Avenue. They just so that's what I have.
Okay, and thank you for that, Your Honor. I know, obviously, we were with each other less than 24 hours ago.
We were.
Court operates, and that's why I wanted, before we get into anything, I just wanted to make sure that my at least is correct as it could be. So the motion that was filed by my office last night is requesting a $2 million bond with the otherwise with house arrest with GPS tether if release, and for him to not be a mile of any school. That would be the request. The concern, my understanding, the concern that gave rise to this renewed request, because at the time of the arraignment, that was not the request of the people, was that the learning of the defendants.
Well, let me just stop you because I don't think that that's true. At the time of the arraignment, and this is something, quite frankly, that people are going to have to explain to this court, there was an original bond request sent for, in terms of its monetary amount, for the $250,000 cash surety. That was, as best I'm able to determine, sent on the 17th. Or shortly. The original one for the $250,000. Within 5 days, there was then a new bond form for the $2 million with some other added changes. I, as best as I could on short notice, reviewed those. What I do not understand is, and just so I'm clear, so at the time of the defendant's arraignment, both of those were before the court. for the magistrate. Both bond forms. This request for the 2 million was before the court at that time. What could not be explained, and I think something that's going to have to be explained by the prosecution, is why the request, particularly for the monetary amount, is changing. Because I don't see any basis as to why, in essence, almost an 8 to 10-fold request for an increase in those 5 days when there's nothing that happened. There's no indication of any other information that came to light that might justify that.
Only response I can give to the court would be to rely upon the written meetings. I have no personal knowledge or information that.
Well, okay, and I get that, but isn't that important? I mean,
I don't disagree with the court.
Because effectively what you're asking me to do is to do something under the court rule, which I can't do, which is to deny the defendant bond. I mean, a $2 million bond will be effectively a denial of bond for this individual, from my understanding. I've had my mini tirade. You can go ahead.
I understand the position of the court. As I stated, I'm relying upon the pleadings that have been filed. I think that at this point, I would move my discussion on, if the court's willing to an exploration of modification of the GPS tether. Or at least clarification, hearing what the court, through its own personal knowledge and experience of the location of Hazley Elementary and the location of the defendant's residence. My understanding is that there is perhaps a residence the defendant can stay at his uncle's home on, I believe it's Ingalls, just kind of other slightly more downtown, you could say. Now, in a quick look on Google Maps, that address does appear to be within a couple blocks of Community High School. I don't know if the court is would entertain. I'm just kind of, as we do sometimes, Your Honor, exploring options on the record.
Right. No, I get you.
And so that's kind of where what I'm looking at now. Ultimately, we have a lot of people in the courtroom. I believe the majority of these people in the courtroom are staff at the elementary school that were affected by this threat. They are concerned for their own safety. They're concerned for the safety of their students, rightfully so. I have a child in elementary school, and the court has its own experience as such. I think that what ultimately we're looking to do is anything we can do, acknowledging the fact that the defendant may very well be out of custody while this matter is pending, that we can as best protect the children of that school and the community at large. And that's what the people are requesting. And I'm open to a discussion as to how we can best do that. And I'm very much aware of the defendant's history. I guess I wouldn't say I'm very much aware, but I'm aware of the defendant's both mental health issues and what I could say the condition that he exists in, through a brief reading of the police reports, as well as discussion with members of the public defender's office. I'm aware of all of those things.
Okay, so, and then certainly I'll hear from the defense, but there was a request that he not go within a mile of any school, right?
You have to leave the city of Ann Arbor.
Absolutely. I mean, because I even this morning was having my staff look and just trying to determine whether or not that's even a feasible condition I could put on a defendant. And a mile, you can't do it. I mean, I think within really a mile and a half, 2 miles of just Hazley School, there are two other elementary schools and a junior high and a high school. So, I mean, I don't even know how that would work, to be honest with you.
Would the court consider a GPS tether with house arrest, so we don't have to play the exclusionary zone game?
I would certainly entertain it. And look at it if that's the request. And Mr. Childers, I realize you're here and I always respect the arguments that you give and you always give good arguments to the court. I'm trying to figure out what specifically are the people asking the court to do? Because when I look at the motion, the request is really threefold. That the people want his bond increased to $2 million cash surety from the current $250,000 cash surety. They want him to remain under house arrest with a GPS tether if he's released, and that he can't go within 1 mile of a school. And so, I mean, is that the people's request? Or
Be possible if we could take a brief break. I didn't file the pleadings, obviously.
I know, Mr. Childers, and I understand that sometimes we're put in a position of having to argue something, but so that you're also clear, I mean, I take what is at least alleged, the safety of the students, the safety of the community very seriously. I can tell the people out there that people that have known me, I've been on the bench 25, 26 years. You can send me all the emails you want. It doesn't affect it. I'm going to issue my decision based upon how the law reads. So you can stop sending the emails because, quite frankly, they don't get to me until afterwards, and they have no effect on me. I need to know what the people want, what the defense wants, and then I'm going to make the call. And there are going to be those that don't like it. There are going to be those that like it. But that is irrelevant to me in a lot of ways. I'm not here for a popularity contest. And I think there are some people that need to realize that in terms of what they file before this court. I don't play a popularity game. I do my job. I will give you a break. You can take the defendant back and we'll come back out and I'll hear from the people and the court stands in recess. All right.
All right. Yeah, like I said, serious case. We got a lot of teachers and parents in the gallery, and apparently they're emailing Judge Simpson. I would probably do the same thing if this happened to my kid's school. I'd be emailing the judge, and I mean, you can't do that though. They're not going to read them. But I understand the want to do that. It's not appropriate. It's not. I want to so badly just side with the prosecutor on this one, but I feel like there's some weird things going on in the background. You know, raising his bond from 250,000 that he posted to 2 million, making some bond conditions that can't happen. It's just you're I don't know. I don't know. I don't know what to say. Let's just see how Judge Simpson rules.
Most case of the people versus Jules Calpo.
Andrew Childers appearing on behalf of the people.
Ron Brown appearing on behalf of my client.
Right.
Thank you, Your Honor. I appreciate the
You can't send them directly to judges. I mean, you can't, like, if you have the actual judge's email, you can, but it's not usually the judge's email is not public information. The court's email is. You can look up a court and send it to, the court clerk. I mean, yeah. So those emails would generally are acknowledged. A lot of people don't do that though. It's not like they receive a ton of these, but as you can see, there's a bunch of concerned parents and teachers, rightfully so. So they're they probably emailed him, and same with the prosecution. Keep this guy in jail. We don't want him out, which is understandable. The problem is the guy has rights too. Unfortunately, in situations like this, you can't just change things. Could you imagine if, hey, we don't want you out. You posted a $250,000 bond. We didn't think you could get out, so we're going to change it to 2 million, so you can't get out. You can't do that. Some cases, you wish you could, but you can't.
Opportunity, I've spoken with the chief assistant elected prosecutor, and the petition that we are requesting, I would call it modified off the written pleading. What the people are requesting is and I don't believe in my discussions with the public.
They closed schools today. So they closed the schools today. He's clearly still in custody. This happened a couple hours ago. So maybe he's been released as of now. We'll see how this ends. But yeah, they closed the schools today because he posted bond yesterday. And when he posted bond, the teacher, the faculty, and the students all, they called in, they called in sick, whatnot. So they closed the school. I mean, it's a big deal. It's a big deal. I'm not trying to make it. I'm not trying to make light of it. I'm not trying to make light of it at all. They probably should have set a $2 million bond from the get go. Maybe they asked for it. I don't know. We don't get to see the arraignment.
Defendant's office, this is something that they're opposing. The house arrest at the uncle's address on Ingalls, so it would be a GPS tether with house arrest. Commander Shipakasi from the jail has been or is currently in communication with the deputy chief at Ann Arbor Police and coordinating with the uncle to have Ann Arbor Police go through the residence prior to the defendant being tethered there to ensure there are no weapons in that home. And I believe that we would allow the defendant has medical appointments at CMH and a doctor. We can figure out those details, but we would allow for release to verified medical appointments from the Ingalls Road address.
Right.
That's correct, Your Honor. We'll figure out the details and present an order to the court.
Well, you'll figure out the details of the appointments.
We have the appointments in the address. 2 at CMH and 1 with a Dr. Colin, whose office is at 3300 Washington Avenue, right now.
But are those regular appointments? So they're going to occur at a particular time or what?
Through today, for the next week, we know of these appointments. But once he's seen, we don't know of when he will be seen again or scheduled again. They're intake assessments.
Thank you.
And my understanding.
That's right. What did you hear?
I'll go sit down.
What? Oh, no, you're fine. I'm just saying. I knew somebody knew something more than most.
Of course. Usually in my experience, if we allow for them to, there can be an aspect where the defendant is communicating with community corrections.
Correct.
If this particular doctor, I know appointments change and things like that. We don't need to have an order reflecting every single appointment. But the people we would have no problem provided they are verified with the defendant seeking the treatment at CMH and with his doctor.
All right. So just so that I'm clear, the request for the increase in bond monetary amount is withdrawn.
They're no longer making that request.
The request for exclusion zones is not needed.
My favorite quick cocktail is root beer and vanilla vodka. I'm not too proud to admit that. As I bartended for a while, and that's my favorite. If you just want liquor and soda, perfect. It's perfect. But vanilla vodka and root beer is amazing.
Only because he'll be under house arrest. All right. And then what did I say the other one was? All right. So really, the second one is just a modification of GPS tether to a house arrest.
Judges and magistrates, the difference is it honestly depends on the jurisdiction. Kind of what they all have in common are judges are generally elected and magistrates are appointed. That is mostly true in most jurisdictions, but it does vary. It does vary. Um, a lot of jurisdictions are set up where magistrates will handle, arraignments and yeah, essentially arraignments and civil matters, and the judges will handle sentences and felonies. But it all depends on your jurisdiction. If you're in a jurisdiction that has a district and a circuit court, that's also going to change it, which a lot of bigger cities have that. It's not an easy answer. I've asked that multiple times to a lot of different people. So I've gotten a few different answers, but the biggest thing is judges are elected, magistrates are appointed. Again, it still varies. It's like the law. It depends.
Correct.
All right.
And Brandon Casey from Community Corrections was already sending me messages that they're aware of this address and
they're aware of the Ingalls address?
Correct.
All right.
Your Honor, we've also spoken to the owner of the 110 North Ingalls address, and he has consented to the police search of his home for weapons.
All right. And that's a single.
It's an apartment. It's an apartment.
It's an apartment. Council approach. All right. I'm going to have to pass this matter again because I got to figure out one thing about the location and address. So we can take him back and I'll pass it. Ms. Pearson, feedback in.
Yes.
To recall the case of the People versus Jules Calpine.
Andrew Childers agreeing on behalf of the people.
Ron Dunn, on behalf of my client. Should we approach with the answers that the court gave?
No, that's okay. I presuming you checked.
Serious question. He has got Attorney Brown, downtown Lauren Brown, as his attorney. That's a public defender. He posted a $250,000 bond and has a public defender. Did he hire him privately? I mean, that could possibly have happened. Public defenders do take private cases, but yeah, that just hit me.
Concerns of the court.
Yes.
And have filed with the court a stipulated order for release from custody, which the court, while in back, has reviewed, finds that it is appropriate, and that it addresses the issues both of the needs of the defendant, which important, but also not considering him to be a risk of flight, does primarily address the issues of concern and safety for the public on this. And I would note that I believe he has a preliminary examination, or not preliminary, but probable cause conference, which is scheduled before me for this upcoming Thursday.
Yes, Your Honor.
All right, because it was rolled up in terms of time. I appreciate the parties working it out. I have signed that order. What we will do also is we will review it. We'll prepare a community corrections order so that everybody is straight regarding the GPS tether and exactly what's going to happen with that.
Yes.
All right.
So the court's aware, my understanding is it may be happening as we speak, but Ann Arbor we're sending officers to meet the uncle of the address.
To go to the address to make sure that there are no weapons, so that won't be a bar to the release.
Right.
We will get that over there for those that are interested in his release. The tether's gonna have to be in place prior to his release from the jail.
Understood.
So, we will try to make that happen and try to make sure that if it's gonna happen today, it can happen today, otherwise it's not gonna happen.
Yeah, I mean that's possible, Vic, but they're sending him to live with somebody in an apartment. Maybe that's just because it's far away from the school. I don't know. This case is gonna be it's gonna be an interesting case. We're gonna get a follow up on Thursday. Now that I started the case, I got to continue it. So we'll get a follow up on this on Thursday. There's also another case that's happening on Thursday in Judge Simpson's courtroom. Oh, was it the coach? Maybe, hold on, I gotta sneeze. Hold on. Oh, that came out of nowhere. Woo. All right. Bella, thank you so much for the 5 gifted memberships. I appreciate it. Welcome to the 5 new members. Bella, you are awesome. Thank you. All right. Unfortunately, because my little snafu with the volume for the first clip, that's all I had. I had a nice long video plan for the night, but we lost 20 to 25 minutes of content because, yeah, the volume of the video sounds great on my editor, but not when I compile the video. I was worried about that too. I should have checked it. Because, like I said, when you're watching the court on YouTube, the volume is super low, and then when I was playing it in my editor, the volume was normal. It sounded great. I should have checked it. Anyways, I'm sorry. I'll put that video for Sunday night. That is it for tonight, guys. Yeah. Hopefully the community's safe. I th- I've got issues with this case for on both sides. I think the raising the bond after he posted it, that's weird. That's weird. I don't like that. I don't like that. I mean, but outside of that, the guy should be he's threatening a school. You should be in jail until your case is resolved. I'm sorry. I really believe that. You threatened a school, but it's still he's innocent unless proven guilty, right? So he's got a chance at bond, and bond isn't supposed to keep you in jail unless it's a no bond hold. It's not supposed to hold you in jail. It's supposed to, you know, supposed to prevent you from fleeing, protect the community. You have something to lose. So this one was tough. This one's tough, and now you know why I don't like doing tough cases because this is where my head goes. Because I'm on the side of the prosecution where I don't want this guy out, but at the same time, can't do sketchy things. Anyways, you guys are awesome. Thank you so much for hanging out with me tonight. Biggin, thank you for the raid. I appreciate it. Everyone that came over from Biggin, you guys are awesome. Thank you. Thank you everyone for the super chats, gifted memberships, membership milestones. Again, mods, thank you so much for your hard work. Muse, I'm gonna go refresh the GoFundMe. Hopefully, you got some donations from the community tonight. I'm gonna continue to push it for the next couple days. Probably Sunday, Monday, maybe Tuesday. I don't know. We'll see. We'll see how long it takes to make the goal. But Muse does need some help. For anyone that's coming in later and watch this on Rewind, I'll put the GoFundMe into the description so you can see it, because I know sometimes chat doesn't appear after live streams. YouTube just disables it for some reason. I don't know. But that's it. That's all I got. Have a great weekend. Tomorrow night I'm off. It's date night, so I'm gonna be hanging out with Heather. I'll see you guys on Sunday night. Okay, now I'm just talking to make the video last longer. You guys are awesome. Till next time, bye.
Till Monday.
Understood.
All right. Thank you.
Thank
Everybody have a good weekend.
Thank you.